Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss a case law on Order 7, Rule 11 of the CPC. It will be useful for the CPC students who are now dealing with the same topic. Therefore, I am making this video since it has come to the level of the Supreme Court. Basically, Order 7, Rule 11 cannot deal with the res judicata at this particular point of time. Or res judicata cannot be decided under Order 7, Rule 11 as the previous suit, previous documents they have to be seen. This is what is stated by Justice Abhay Srinivas Okha and Pankaj Mittal in the case of Keshav Sood versus Kirti Pratap Sood. Keshav Sood versus Kirti Pratap Sood in Criminal Appeal number 5841 by 2023, decided on 12th September 2023. So, before starting the video, let us know what is res judicata. According to Section 11 of the CPC, if any matter has been directly and substantially the same between the same parties, and if with the same matter has been decided a court, maybe the same court or some other court, then this court will not take up the matter. That means previously decided, or decided means heard and finally disposed of. So those cases will not be taken up. If it is res sub judice, you know Section 10, stay of the suit. Now coming to Order 7, Rule 11, rejection of plaint. Rule 11 deals with the rejection of plaint, when it can be rejected. So the point is 11D, it is barred by law. So res judicata already says that the matter is decided, then it is barred by law. Now let us go to the case facts. So the appellant, that is Keshav Sood, he was the defendant in a original suit. He was the defendant, right? So while filing his written statement in an OS filed against him, he has pleaded res judicata under Rule 11 of the Order 7. He filed a written statement stating that the case is barred by res judicata, which is barred by law, therefore it cannot be taken up. But at the time, the single judge, he rejected the written statement stating that the documents are not sufficient. Then he approached the division bench, right? Appeal to the division bench. So appeal to the division bench said, no, single judge is not correct. His version should be heard and it should be decided. Already I told you, just like our 47 CPC, of course, that comes at the time of EP. Here we are only in the suit stage. So, single judge is not correct. Plias chef res judicata should be decided ultimately. So, then once again this man came to the Supreme Court. Supreme Court now clearly said that there is well settled law regarding Order 7, Rule 11 CPC. No doubt, if he files a case of res judicata, the court has to look into the actually the facts, the previous judgment, the pleadings, including the pleadings, because to come into the fold of the res judicata, the case must be one and the same between the same parties. The matter should be directly and substantially the same. If the matter is directly and substantially the same, he would not have filed it. There is some litigation that has to be decided only separately as res judicata, but not under Order 7, Rule 11. Rule 11 says barred by law, expressly or impliedly barred by law. That is the main point. So Rule 11, at the time of reading Rule 11, the judge has to decide whether it is barred by law or not. That's all. That means he can look into the averments mentioned in the plaint. At the highest, he has to go one of the documents. But For proving res judicata, he has to file the previous suit, he has to file so many things attached, he has to file the pleadings also. This is just like a separate suit. So, the court opined that the adjudication or the judgment on the res judicata involves complex considerations. It involves complex, manifold complications like the complex considerations like res judicata needs a detailed examination of the various elements, including previous pleadings in the earlier suit also. So, judgment of the trial court is correct. Judgment of the division bench not correct. Of course, reliance is placed on two important cases. One case I will tell you, that is V. Rajeshwari versus T.C. Saravana Bhava. V. Rajeshwari versus T.C. Saravana Bhava 2004. So please remember, here not only plea of res judicata, but the substantive material is also necessary. But what we are telling in the written statement, the pleading should only plead only facts but not the law. You need not entertain all the judgment copies. So that is the problem here. So please remember, Order 7, Rule 11 deals with the rejection of a plaint, whether it is barred by a law or not. But for res judicata, definitely a separate, detailed discussion is necessary. This is what is stated by the Honorable Supreme Court of India. So, if you want to write on res judicata, you can cite this case law. For that only I am making this video. CP students, please avail this opportunity. Read the judgment and enrich your legal knowledge. With this, I am concluding. Thank you.